You write a weekly column for the New York Times. I'm wondering if you could say a little bit about what your role is there.
Well, I could put it humorously by saying my role is to figure out what will get a rise out of New York Times readers and then write about that. But in general, I'm in the deflationary business. That is, I'm deflating certain kinds of concerns or thoughts. And usually they're ones that liberal New York Times readers have. So I wrote a column against conservation and why I think it's a bad idea and why I resist all my wife's efforts, she is a conservationist, to do horrible things like make me buy green toilet paper, which is like sandpaper, and things like that.
So what do you think the use of that is?
They're just to amuse me. Only a small percentage, maybe 5 to 10% of the columns are like that. More often than not, I'm writing about 2 or 3 areas that I guess I've made my special interest. One is education, free speech on campuses, then on legal questions, on Supreme Court cases.
How did you come to be a professor of law?
That's what my mother always wondered about. You know, you can't please your mother. My mother and father didn't want me to become a professor of literature. They thought I should become a lawyer. And then I, later on in life, became a law professor. And so I used to play basketball with a friend of mine who was in my department of English at Johns Hopkins, and with a third friend who was then a law professor at University of Maryland. And we found out that there were some intersections of interest or between the law and literary studies. So we decided to teach a course together, the 3 of us, which we did.
What in particular was your fascination with the law?
The general issue of interpretation and how it works and what evidence for interpretations are and what makes a persuasive interpretation and when are interpretations legitimate or illegitimate.
You have a new book coming out
Called How to Write a Sentence, and then there's a subtitle, How to Read One, and How to Read One.
Tell me a little bit about it.
I was asked by HarperCollins because I had been writing occasionally in the New York Times columns about the teaching of writing in this country and explaining why it had gone off the rails since the 60s and gotten worse and worse, and that writing courses had ceased to be courses in the craft of writing and instead become courses in readings about oppressed and marginalized peoples. I don't see why reading about oppressed and marginalized people has anything to do with learning how to write. So I myself began to teach writing courses once again. I always have, but there was a period when I was at Duke when I didn't. And I began to teach writing courses. And I developed a theory or a method or at least a bunch of exercises, which I thought were helpful. So I was, in a sense, ready to write this book. The second emphasis of the book is on sentence appreciation. It's kind of a hit parade of great sentences from many, many people, maybe 50 authors, maybe more. I haven't made a count yet, in which I try to explain what makes these sentences great and also try to tell people how they could imitate them if they wanted to try. So it's kind of a, as my wife said, a love letter to sentences.
In the legal profession and for law students, reading and writing and enjoying reading and writing doesn't necessarily come naturally for many of us.
No, it doesn't. There's nothing natural about either activity. Go through some sentences and explain how extraordinary they are. They're kind of like incredible feats, F-E-A-T-S. John Updike, the American novelist and poet and essayist, happened to be in Fenway Park the day that Ted Williams hit a home run in his last time at bat. So he's writing about the ball as it leaves Williams' bat. And here's the sentence. He says, "It was in the books while it was still in the air." It was in the books while it was still in the air. Well, that's a remarkable sentence. All monosyllables, extraordinarily powerful, doing several things at once, and yet it seems effortless.
Do you think that the Supreme Court has ever hit a sentence out of the ballpark, and if so, what is it?
One of my big examples early on in the book is from an opinion by Scalia. Scalia, in a case called Lee versus Wiseman, the last big school prayer case, 1990, a man named Wiseman brought the suit of action because at his daughter's graduation, a prayer was read. So the court nevertheless found in favor of Mr. Wiseman and against the school district, saying that although the prayer, no one was required to even stand during the prayer or say amen after the prayer or pay any attention to the prayer, nevertheless, the very fact of the prayer, the court said, and we will read this case later on, constitutes psychological coercion on the part of the state with respect to young Miss Wiseman. Scalia goes crazy. First of all, he quotes a colleague of his who says that in general, Establishment Clause jurisprudence is becoming so Byzantine that it's almost a version of interior decorating. But then he gets off his sentence. You've got to imagine him sitting on the bench and looking to the left and right of him at his colleagues, and he said, "Interior decorating is a rock-hard science compared to psychology practiced by amateurs." Now, that is a hell of a sentence. It's like he's just loaded a gun, cocked it, and shot it, and hit his colleagues before they even knew what was happening. And the swiftness of the sentence is what makes it work, and I'm able to explain why the sentence is so swift.